Hello everyone. Let me begin with thanking Wonder Woman Connect and Miss Arpana Agarwal ji for giving me this opportunity to speak to you all. Well friends, I have been associated with Wonder Woman Connect since some time now, and I have seen the hard work and diligent efforts by Arpana Agarwal ji in each of her programs. Now, I admire her ability to organize such socially and intellectually stimulating events. So, here I am today to tell you about how to make a will sitting in the comfort of your own homes. Let me first tell you that you do not, and I repeat, you do not need a lawyer to make a will. Well, I have received some questions on making of the will from your group members, and I will answer them all while discussing this topic. But first things first, let us first understand what is a will. Well, friends, will is made and governed by the Indian Succession Act 1923, and Section 2H of this Indian Succession Act defines a will. So, what does it say? Well, it says that will is a declaration of the intention of a person with respect to his property which he desires to take effect after his death. Now, I'll simplify that for you. Well, it is first and foremost a declaration of your intention. That means this is your intention to make a will and what you want to put in that will. Then it should be with respect to your property. That property may be movable or immovable property, and that you desire to take effect after your death. That means even if you put anything in the will, it will not come into effect except unless after your death. So it's very safe to make a will, and in fact section 62 further adds to your advantage and says that the will that you make can be revoked or altered at any time. So it's not that if you made a will today, you remain bound by it. During your lifetime, you may also dispose of your properties even if you mention the same in your will. Now, you can be very sure that once you put any properties that you mentioned in the will, that you will want to give it to your children after your death in whatever manner you deem fit, and in the middle of it, somewhere later in life, you decide to dispose of your properties, feel free to do that. Nothing wrong. You are totally entitled to do so. But let us understand, why is it important for you to make a will? Well, this question comes to me a lot of times. Many feel that our children will not fight after my death, so why make a will? Very logical. But first and foremost, you should make a will because you can give your properties as per your wish. Not only this, you may give your properties to your children or to anyone in the family or to a charity or even to a friend. Anyone. But if there is no will, your properties will automatically devolve upon and be divided equally amongst your legal heirs. So, in case you have more than one legal heir, say two of them, who are entitled under law to get 50% share each in case you have not left the will, then after your demise, they will have to approach the court for partition of the property to decide and demarcate which portion of the property would constitute their share of the will. Say, for example, one son may say, no, I want the front portion. The other may say, I want the back portion, because the will only, or there not being any will, only defines a 50% share, but it does not define which part of that 50% will belong to whom. With a will, you can partition the property as you would want and define the share of each of your legal heirs. Well, friends, you can also attach along with your will a site plan of your property. Then you can mark one portion in red color and another one in blue color. Of course, I've just given these colors as an example. You can choose the colors of your choice. But those colors will only define and mark a certain portion, and then you can mention in your will which marked portion of the property will belong to which legal heir. Now, for a partition suit, this is another one of the reasons why you should make a will. A partition suit would otherwise, for it to be implemented, your children will have to approach a court, engage a lawyer, and this may take a few years. But with a will, you can help your children avoid spending this time and money. Another reason why you should make a will is that many government authorities need a succession certificate or a legal heir certificate after their demise to transfer the property in their name. But with a will, those certificates may not be needed. Again, it depends from which government department you are approaching. It may be DDA in Delhi, it may be Gurgaon development in Gurgaon, and similarly wherever it's required. Now, supposing you have children who are minor, that's kids about under the age of 18 years, and you want to designate a legal guardian. This is a very important reason, because I understand a lot of you today who are listening here would have children who are minors today. And of course, life is uncertain. So if you want to protect the interest of your minor children, obviously they cannot inherit your properties and be entitled to use them as they wish, except through a legal guardian. But who would be that legal guardian under law? That would remain under the decision of the court. But in your will, you can designate a legal guardian who you can say will take care of your children until they are adults, who will also take care of your properties till your children become adult. In case you don't have any particular person in mind, you do not wish to trust a single person, you can make a combination of a few people, set up a trust with those few people, because a trust will function on the signatures of all, and then you can will all your properties to that trust, which will be given the task to oversee and be responsible for your child's funds until they are old enough to inherit your property and your money. Till then, the trust will remain as the caretaker of your properties and will devolve upon them after they become a major, and once they become a major, the trust will automatically dissolve. I'll give you an example here. It's very interesting. Now, supposing you wanted your minor daughter to have 50 lakhs for her higher studies, and not leaving a will would amount to this 50 lakhs in your account to be distributed equally among, say, 5 legal heirs. That means the daughter for whom you wanted 50 lakhs to come will now inherit only rupees 10 lakhs under law. The whole purpose of making a will is that you want to interfere with the normal line of succession. You want to give more to one child, less to another. Or maybe not anything to any of your children, but to some other third person. Just keep in mind that you should clearly mention in your will the following details. First and foremost, all the names should be correctly put. The addresses should be correct. The date on which you are making the will should be there. Please note these down. I will repeat them though. The full name and your relationship with the beneficiaries. You must mention as to why you're giving a certain thing to whom. What is your relationship with them? Are they your children, your husband, your brother, your parents, anyone? You must mention your assets very precisely. You must mention if there is a property, what are the details of that property, if it's a bank account, what is the bank account number, and so on and so forth. You must have it done in the presence of two witnesses, and you must sign it along with the witnesses and their details. It should not just be the names of the witnesses, it should also be the details about the addresses and contact details of the witnesses, so that tomorrow, whenever required and if required, those witnesses can be approached by a legal heirs. So I'll repeat a few things you need to keep in mind. One is your name, correctly written, your address, your date, your full name and your relationship with the beneficiaries, your assets clearly defined and laid out. It must be mentioned that you have signed it in the presence of two witnesses and you have signed it along with the witnesses. And you must mention the details of those witnesses, the contact details. Now, one of your group members had put this question to me, asking that wouldn't it be better to just gift the property to your children while you're alive? That would save all the hassle. I would say, great idea. But keep in mind, it's a great idea definitely, because if you gift your property while you're still alive, it will be immune to any other challenge by any other legal heirs. So there will be no fight among the legal heirs. But then the disadvantage is that it can make old people or you all at a later older age, it can make you very vulnerable, because once the property is in the hands of the children, they can start ill-treating their parents. And this, I have seen it in a few cases. There are many cases, in fact, where the children have shifted their parents to old age homes and thrown them out of their homes. That would not have been possible if you have willed the property to your children. Then they would get a right over that property only after your death. But till then, you will have full control over that property. You can also change the will at any stage during your lifetime and ensure that someone else gets your property after your death if you so choose after seeing your children's misbehavior. So the children will always remain at bay because they know that you have the power to change the will at any stage. But in case you have given them as a gift, you cannot change it. They already become the absolute owners to that property, and even you will not have any right over it. You know, a very major example to this, a real life example, which I'm sure all of you would have read in newspaper. It is the case of Vijaypat Singhania, the founder of Raymond Company. If you remember, he had gifted all his shares worth nearly about 1,000 crores to his son, Gautam. And he was around 78 years that time. And he was literally made to beg for his own property. This came in a lot of newspapers. A very live example, a very famous example, in fact, the founder of Raymond Company. So with this, I would definitely recommend that you should make a will. Now, when you decide to make a will, obviously you should know whether you are eligible to make a will. So what makes you eligible to make a will? Well, first and foremost, just keep in mind that you are a person who is of sound mind. You're not mentally unstable in any manner. You're not a minor. A minor cannot make a will. And you're not, at the time of making the will, you're not in a state where you do not know what you're doing. Say, for example, when you're totally drunk with alcohol or anything, and you do not know, you're not in your senses, and if you made a will at that time, it will not be a valid will in the eyes of law if proved that you made the will when you were not in a proper state of mind, or if you're mentally unwell for any reason. Even for a short period, during that period, you cannot make a will. So keeping all these things in mind, after having understood what is a will, why you should make a will, and whether you are actually eligible to make a will, the basic question that arises and the reason why all of us are here today is to understand how to make a will. Like I said, you do not need a lawyer to make a will. Section 63 of the Indian Succession Act makes it very clear that if three things are squarely covered in your will, a piece of paper that you will write on a blank piece of paper, then that would be a valid will and enforceable in law. Now, what are those three things that Section 63 talks about? Well, first and foremost, it should be signed once you've written whatever you desire to give to your children or your legal heirs. It should be signed by the testator, that is you, in the presence of two or more witnesses. So please keep in mind, it has to be two or more. It cannot be less than two. It cannot be one. So there have to be two or more witnesses, and you should have signed in their presence. The witnesses should sign in the presence of the testator. So they should sign in the presence of the person making the will and should have seen the testator signing it. So it's not that you just make a will, sign it, take it to your friends and say, please sign it now as a witness. No, that doesn't work. They have to sign it in your presence so that they can see you signing. And the signature of the testator should be placed in such a manner that it appears that it was intended to give effect to the writing of the will. So whatever you have written, it should be clear that your signatures are just below it. Not that you've written everything that you wish to say or to give it to your children on one page, but you sign it on the next page. Don't do that. Do it where you've written it on the same page. If it's half written, sign it where it ends. Don't sign it at the end of the page, because then it will give a doubt that the person or one of the legal heirs who was benefiting from this will got it signed by you on a blank paper and later fill in the details to benefit himself from your properties after your death. So again, a will made on plain paper is a valid will. But if it's comfortable for you, I would suggest you should get it notarized by a notary public, because in his presence he would know that you intended to make the will, you signed it in his presence, and he will attest it. If it's more comfortable for you, then I would recommend that you should get it registered. Now, having said that, I will repeat that a will made on a blank paper is a valid will and equally enforceable in law as a registered will. So that is why I've used the words, if it's comfortable for you, then get it registered or notarized. Otherwise, if you've just written on a plain piece of paper, it is an equally valid will. Now, it's just that if it was registered, then it's always easier to prove for a legal heir in the court, in case of a dispute, that the will was a properly executed and a genuine will. So don't just not think of making a will, thinking that you will have to go to a lawyer or a sub-registrar's office for registration. No, you don't need to do that. Today itself, after this discussion, you can simply sit back, take out a piece of paper and write whatever you want to give to your legal heirs, to your children, in whatever manner you want. Just do it on a simple paper. That would do. Just ensure the three basic requirements of Section 63, which are a must to make this a will, a valid will in the eyes of law. Those three things are: once you've written it at your comfort. You don't need anybody at that time to see what you're writing. Nobody needs to know what you've written. But when you're signing it, ensure that you're signing it in the presence of two witnesses, any two people, maybe educated, uneducated, anyone, but it should be signed by you in the presence of two or more witnesses. The witnesses should sign in your presence. It's not that once you have signed it, you go to the washroom and leave it for the witnesses to sign it. No, they should sign it absolutely in your presence, and it should be written in the will at the end that they have seen you signing the will. Now, these are things where people lose a case on a will if it's not proved that these three things have happened. The last third thing is that your signature should be properly placed. That means if it's a half a page, then you sign it immediately where it ends, not at the end of the page or on the next page. Now, so far as witnesses are concerned, I would also recommend, though it's again not compulsory, that at least one of the two witnesses should be a doctor, because then he can ensure that you were in sound mind at the time of making the will. Generally, people can take any two people. Even your servants at home can become witnesses, not a problem. Just ensure that their contact details and addresses are properly written so that at any stage, if required, those witnesses can be called for. Yes, like I said, it's always better to write a date on the will to help your legal heirs know when this will was made. For the court also to understand, okay, it was made on so and so date. Yes, at that stage in life, you were in good health and in sound mind. Another thing that you need to keep in mind is that you can only make will what is yours. A lot of people have this tendency that they have a property in joint name with their husbands, and they would just make a will saying that the entire property would go to their son or daughter or whatever. But that is wrong, because in a joint property, you would have only 50% share. So definitely you can will only 50% share of that property and not the entire property. Similarly, you should mention when you write about your immovable property, like your bank accounts, your share certificates, you must mention each and every bank account. You should mention as far as possible. It's not that if you forget, it will make it invalid. But if you do remember, and preferably try to dig it out, mention your bank account with the account number, the bank name, and the address. In fact, I would suggest you should also, if you remember, do mention the nominee, preferably the nominee and the person you are giving that account in your will should be the same as of the nominee. And similarly for investments and insurances, let the scheme name, the number, the financial institution, and the insurer should be written along with the addresses and with the name of the nominee in every movable asset that you have. Now, later in life, if there is any alteration in the status of your assets, you may sell your assets, you may buy some more, or there is a change in the status of your legal heirs. Maybe you're born with another child. You should draft another will at that time and incorporate those changes in the new will. Keep in mind, there is no limit on the number of times you can make a new will. So, at any stage in life, whenever there is a development, like birth of a child, a marriage, or divorce, it will obviously call for a redistribution of all your assets. And similarly, if any asset has been sold or new ones brought during the lifetime, then the old ones have to be removed and the new ones have to be included in the list. And that is the reason why the law gives you the power to keep making wills one after the other. And when you make a will, you can mention about your last will and the date of that last will, that you did make it, but now you are changing it. So anyone who's making use of that will can come and say, yes, this is the last and final will made by my parents. Now there is another very interesting thing in will. Do you know that you can also make a joint will? A lot of people do that. You can make a joint will along with your husband or whoever you have properties with. And in that, what you can write is that you and your husband have these properties in individual names and so properties in your joint names. And both of you intend to will it in a particular manner, in the same manner. Maybe a certain portion to one son and a certain portion to your daughter or the other son. But both of you intend to distribute the properties in the same manner. In this case, what happens is, in case any one of you dies first, the properties will go to the other. And only after both of you die, then the properties will go to the children in the manner you both have decided. Now, keep in mind that a joint will cannot be changed after the death of one. Unlike an individual will, you can keep changing it as many times you want. A joint will can also be changed as many times as you want, provided both of you are alive, the husband and the wife, or the person with whom you've made the joint will. But if any one of those persons is no longer alive, then the other person who had made that joint will cannot change it. Now, some people feel that this is a good thing because the children now cannot influence the parent who is alive and influence them to change the will. Some feel it is wrong for the same reason, that tomorrow I may want to shift and give more to a particular son who's taken care of me. That also cannot be done because it's a joint will, so that's a disadvantage. So the same reason that you cannot change the will after your death can be an advantage or a disadvantage depending as to what you have in mind. So when you make a will, you should understand who are the parties in a will. Well, the basic parties to the will are three. One is you yourself. You, the person who's making the will, is called the testator. Then comes the beneficiary, the person who will be inheriting through your will. It may be your children, your legal heirs, or even a third-party organization. Like I said, you can build a trust. You can give it to a charitable organization as well. Daan kar diya. I don't want to give it to my children. They'll make their own. But whoever that person is who is benefiting from your will becomes a beneficiary or is called the beneficiary. Third is the executor of the will. Now, executor is not always necessary to be appointed. Just the testator and the beneficiary is simple enough. But you may appoint an executor. Now, a lot of people do that. Why? See, when after your death, there is somebody, it's not only that you are only having all the assets you've already gained. You would have loans, you will have debts of some kind or the other. So you can mention in the will that these are the debts, and I would want the executor, who would be a person of your choice, of course, to first pay off the debts from my money after my death, and then what the balance has been left, he can distribute it amongst the beneficiaries or my children, whoever they are. Then the executor can also help you manage your assets until they are dispersed. Like I said, if the child is a minor, the executor can take care of all your properties and assets and distribute it once they become the major, or in any other situation where you feel the executor should execute your will. Now, most people choose a spouse, an adult child, or a close friend to serve as executor, but you can actually go to anyone. Some people also appoint their lawyer as the executor of the will. But then again, you're making it yourself. You can choose whom you want. Because a beneficiary also at times, people make them as an executor, but though it's not advisable, because if it's a minor, he'll not be able to execute it. If he is somehow trying to benefit from that will, he can take advantage of it. So generally not advisable, but under law, nothing stops a beneficiary also to become an executor. Now, understanding that these three people will become a party, possibly two, but preferably three, in case you decide to appoint an executor. You should also understand in what situations a will can be challenged as a bad will or a void will. So keep these small things in mind so that when you make a will, it should not become a bad will. Now, what is a bad will or a will which the court can say, no, it's void, cannot be enforceable? When a will is uncertain and the bequest is not expressive of any definite intention, it will be void. Section 89 says this. That means even if your English is bad, but your intention is good, it is a good will, it's a valid will. But if your English is very good, but your intention is not well conveyed, then it will become void in the eyes of law. Similarly, Section 84 says, when two or more possible constructions can be made from a bequest in the will, it will become a void will. That means, say for example, let me give you a very interesting example. And all these examples, keep in mind, are real life cases. Now in this case, say for example, I say that in my will, of course, that the front portion of my house is given to my daughter, except one bedroom which shall go to my son. And the space over the front portion may be built by my son whenever convenient to him. Now do you realize which bedroom goes to my son from the front portion? Which space over the front portion? And if he makes it over the front portion, will it block my entrance? And when will he build it? What do you mean when convenient? So be very clear as to what you want to say and whether it's properly executable or not. So Section 87, for example, says that whenever the intention of yours cannot take effect to its full extent, it will be a void will. Now, what kind of a situation? A lot of people do this. They hear a name from say for example, a charitable organization in which they want to donate. They do not verify the correct name or the address. They just mention that after my death, all my properties should go to this XYZ charitable organization. And later, when the legal heirs want to, or the executor wants to execute the will, they realize that no such organization exists. That will also make the entire will, void and invalid. Another one very common mistake people make in their will. Some people write in their will that my properties will go to my grandson whenever he's born. Section 112 says that when a bequest is made to a person who is not in existence, it is a void will. Let him be born, make a will or change your will at that stage, not a problem. Like I said, you can make any number of wills during your lifetime. There is no bar to it. So make a will today. When your grandson is born, change the will, transfer it in his name, or change your property that after your death should go in the name of your grandson. That is absolutely fine. But today, when your grandson is not there, you cannot say that it should go to my grandson whenever he is born. That will make the will invalid and void in the eyes of law. So keep these small things in mind. Then let us understand, can this will be revoked? I made a will today, but Okay, I didn't want to make a will. I just made it. Us time mood aaya. I heard the lecture of Sumit on how to make a will, got excited, and I made a will. Yes, at any stage in life, even if you made a will and decide tomorrow not to have a will, feel free to revoke it, and I'll tell you how you can revoke it. You can revoke a will. Obviously, when you make a new will, the previous one automatically gets revoked. Section 70 says that. You can revoke a will by writing another piece of paper that I had made a will and today I decide to revoke it. That itself will be sufficient to revoke your earlier will, even if you have not made another new will after that. Or simply you can burn the will, tear the will, destroy the will in any manner, it will stand revoked. It will also be revoked if it is lost. Supposing you made a will, after your death it is not found, it was last seen by you, it will be invalid and void and stands revoked. Another very interesting reason why the law says the will get revoked, and it is section 69 of the Act, which says that when you get married, the will you made before marriage automatically stands revoked. So your marriage also revokes your will that you made when you were unmarried. So yes, when you get remarried, you must make a new will. Now, registration of a will. A lot of people put this question to me that, and I told you this initially itself. Is registration of a will compulsory? No. It is not, I repeat, it is not compulsory to register your will. A will made on a plain piece of paper is absolutely valid in the eyes of law, just like a registered will. Yes, of course, it has its advantage. No harm in getting it registered, but it's a choice. And there is no time limit to register it. You can make a will today. After 10 years, you decide to register it. By all means, you can do it later also. There's no time limit. Wording of the will can be simple as long as the intention is clear through your words. So don't worry, you don't have to use any technical words. So what all should you be including in the will? You should include in the will the details of the testator. That means your details, your name, age, address, which will help identifying who is actually making the will. Then of course, in the second part, your declaration. What are you declaring? And especially that you're declaring that you are in the sound mind and you're doing this out of your free will. You're not doing it under force or pressure. Details of the beneficiary. Who are actually going to benefit? What is your relationship with them? Executor, in case you're appointing an executor. Who will be the executor and what will he do? Will he manage? Are you appointing the executor because your child is a minor while making the will? Details of your properties and assets. What properties you have, which bank account number, your property details, everything you should mention very clearly. Then the division, how you want it to be divided amongst your legal heirs. Witnesses, keep in mind, minimum two witnesses are hugely important, otherwise this will is not a valid will. You may be a little bit forgetting any of these first 7 things I said, but if the witnesses are not there, then the will not be a valid will. And of course, you should have signed in their presence and they should have signed in your presence. Now, very interestingly, I'll tell you certain, and if I have the time, I see it's 4:55, but we started a little late. So I'll just conclude by giving you some small examples of real life cases. When I said, that people are able to challenge the will, and this has actually happened where I was a lawyer in one of these cases, where the sisters challenged the will made by their parents and produced by the brother on the ground that it was made by coercion. They had said that my brother had emotionally blackmailed my mother and put her on gunpoint to get the will made in his favor. This may sound crazy, but this is true. Cases like this happen. Then there are cases where after it was a joint will, after the death of one, After death of the husband, the mother was treated like a shuttlecock in the family. It was observed by the Delhi High Court. They said, what are the children doing? Just to influence the mother, the one child would force her to stay with her, the other would force her to stay with her. They would keep making her shift 6 months here, or 6 weeks here, 6 weeks there, where the court held that, listen, both the children are only using the mother, using her like a shuttlecock, throwing her from one place to another, because she had decided to give all their properties to one child. So the other child comes, brings the mother home, and tries to influence them back. That is where the joint will comes into picture and helps you. Presence of a suspicious nature is another ground which is generally used. That at the time of making the will, the mother was unwell, she was in ICU, so she could not have made a will. That is where your date comes into picture. Your witness, if it's a doctor, will help in such cases. Absence of any testimony, intention, or capacity. Say, at the time of making the will, my mother was unwell. Or say in a case where there is no proper execution. Like I said, the witnesses, instead of two, only one witness had signed. The will can be challenged. So keep these things in mind and make a good will, a valid will in the eyes of law. You can do that sitting in the comfort of your own homes. So I hope all your queries that you had put, the questions that you have put to me through this group, are stand satisfied. And in case anyone still has any doubt about how to make a will, feel free to send me a message on this Facebook group. And I once again, before I end, would like to thank Wonder Woman Connect and Miss Arpana Agarwal ji for giving me this platform to discuss the basics of how to make a will. I hope all of you have benefited from today's discussion. Thank you.